10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Start. The High Court, by its impugned order, noticed the provisions of sections 437 and 438 of the CRPC. Stop. It also took note of decisions which stressed upon the value of personal liberty and observed that the court has to exercise extreme care in imposing restrictions in regard to travel. Stop. The court was influenced by two decisions of the Delhi High Court and the Gujarat High Court respectively, K. Ramani versus State, 2014 (10), Criminal 1468 and Department of Revenue Intelligence, 2016 (341). Stop. The court noted in these two judgments that the requirement of obtaining permission prior to travel have been dispensed with. Stop. Taking due notice of the fact that the respondent was a frequent visitor and had in the past participated in certain conferences, seminars, etc., it proceeded to modify the terms of anticipatory bail conditions imposed earlier. Stop. Para. The impugned order stated that the respondent was no longer under an obligation to seek permission to travel abroad, and directed him, instead to furnish an undertaking in writing before the investigating agency, that he would make himself available during the course of investigation of trial as and when required, apart from furnishing the details of his travel to the investigating officer, including the place where he was likely to stay, the countries he proposed to visit, and the date of departure and return. Stop. The impugned order further held that these would be deemed to have been incorporated as conditions of bail till the presentation of the final report. Stop. Thereafter, the same undertaking was required to be furnished before the trial court. Stop. The trial court also was ensured that the trial of the case was not be adjourned or deferred on the ground that the petitioner undertook to travel abroad. Stop. Para. It is argued by the petitioner that the modification to the original order granting anticipatory bail is patently erroneous and contrary to the letter and spirit of section 438 (2). Stop. It is argued that having regard to the seriousness of the crime, and the fact that no important change in circumstances was brought to the notice of the court, the alteration of such conditions was not warranted. Stop. The learned counsel for the petitioner emphasized that the High Court relied upon two decisions of the Delhi High Court and the Gujarat High Court where the conditions of seeking prior approval were dispensed with. Stop. Learned senior counsel appearing for the respondent, on the other hand, urged that since the charge sheet has been filed as on date, there is no material or ground to continue with severe and repressive conditions which tend to impede the fundamental right to travel abroad. Stop. It was submitted that the only ground pending before this court in another proceeding is whether the juvenile sought to be arraigned as an accused should be tried as an adult. Stop. This question, however, has no bearing upon the respondent's rights. Stop. It is submitted that serious inconvenience would have occurred if the modification were not granted, because in some instances, the grant of permission would have undue delayed and even frustrated travel itself. Stop. Over. तो दोस्तों ये 120 वर्ड्स पर मिनट की स्पीड का डिक्टेशन है. इसे लीजिएगा, लाइक शेयर कमेंट करिएगा, बताइएगा कैसा लगा और ज़्यादा से ज़्यादा शेयर कीजिएगा. अगर इसे ट्रांसक्राइब करने का मन हो, ऑटो चेक करना हो, तो वेबसाइट जो लिंक डिस्क्रिप्शन बॉक्स में दी गई है उसमें जाके आप इसको ट्राई कर सकते हो. ओके, तो मिलते हैं नेक्स्ट वीडियो में. थैंक यू सो मच. बाय बाय.